Hello students and welcome to the lecture. So students, as we know that we are covering the emergency provisions, all right? And basically under this series that these are the topics we have scheduled for the discussion. Like starting with the introduction part, thereafter the national emergency, thereafter the parliamentary approval and the duration, thereafter the president rule, thereafter the financial emergency, there is a criticism of emergency provision. So far, basically we have done with the introduction part. We have been discussing the national emergency since the last lecture. All right. And the topics we haven't started or we are left with is the parliamentary approval and duration, president's rule, national emergency, and the criticism of the emergency provision. All right. So basically, in the last lecture, we had discussed about the national emergency, which is powered by Article 352. Okay. We had discussed that prior to the 44th Amendment Act of 1978, the president alone could make emergency proclamation, right? But after the 44th Amendment, 1978, what happened? That basically Parliament approval is required for emergency proclamation by the president. Okay, that is what we have discussed. Thereafter, another thing which we had discussed was that the Parliament is required to pass the proclamation from both the houses separately with the provision of a special majority. All right, a special majority means then 50% members sitting and voting. Thereafter, thereafter, at least 2 by 3rd members sitting and voting must be in favor. All right. That is what we had discussed. Thereafter, another thing we had discussed is that for the continuation of national emergency, because after making the proclamation for the 6 months only, the national emergency could be in force. Thereafter, it's required the approval for its continuation. So, for the national emergency continuation, both Lok Sabha and Rajya Sabha are required to pass the resolution. All right. But for revocation of national emergency, for revocation basically, only Lok Sabha alone would take the decision. All right. That is what we had discussed. So this is the little bit revision of the previous lecture. Okay. Now let's move ahead. Okay. So basically in the previous lecture, we had started the effects of the national emergency on the center-state relations. Okay. And we call it as an effect on the political system of the country. Okay. And these are basically grouped into the three forms. First is the effect on the center-state relations, effect on the life of the Lok Sabha and the state assembly, effect on the fundamental rights. Okay. So let's start with the first thing, effect on the center-state relations. So while a proclamation of emergency is in force, the normal fabric of the center-state relations undergoes a basic change. Okay. This can be studied under the three heads like the executive, like the legislative, and like the financial. Why? Because these are the power divisions between the central government and the state government. Because the power divided between them on the basis of these three categories. So the first category is the executive. So executive during the national emergency, the executive power of the center extend to directory any state regarding the manner in which its executive power to be exercised. It means right now the central government having the power to direct the executive branch of the state government that how they should work, how they should function, and what actions they are required to be taken on. But in the normal times, the center can give executive directions to a state only on certain specified matters. It means that the direction giving power lies with the center in the normal times also. But on that time, only the executive directions to a state could be issued only for the specified matters. Not for everything, but only for the specified matter. All right. However, during a national emergency, the center becomes entitled to give executive directions to state on any matter. Thus, the state government are brought under the complete control of the center, though they are not suspended. It means that the central government is not going to be suspended during the state government is not going to be suspended during the national emergency, but their power to function as an executive branch completely comes under the central government's supervision. Why? Because in the normal times, only on specified matters the central government could exercise the powers. But when it's a national emergency, on any matters, the central government could give the directions to the state. All right. Thereafter, point B, the legislatives during a national emergency. Okay. The parliament becomes empowered to make laws on any subject mentioned in the state list. Like whenever we talk about the legislative power division between center and the states, then it is basically done on the basis of two: union list, state list, and the concurrent list. Union list, state list, and the concurrent list. On the basis of these three. All right. The union list completely falls under the central government. The state list completely falls under the state government, and the concurrent list basically between the central and state government. All right. So on the union list, all powers reserved for the central government. On the state list, powers are reserved for the state government. And on concurrent list, both the central and the state government could take up the chances. This is for the normal times. Okay, when the situations are normal. But when this is a emergency situations, all right. So basically, the parliament, which is at the central level, okay, the parliament becomes empowered to make laws on any subject mentioned in the state list. Okay, but although the legislative power of the state legislature is not suspended, it becomes subject to the overriding power of the parliament. Thus, the normal distribution of legislative powers between the center and the state is suspended, though the state legislatures are not suspended. In brief, the constitution becomes unitary rather than the federal. Okay, what does it mean? What does it mean? It means that suppose if there is an any matter of the state government, for example, if we talk about the state list, then there is a matter of police, public health, okay, entertainment, okay. For example, suppose the central government has take up the matter of policing from the state list and make some law. All right. So basically, there would be central law on the matter of policing, but the state government is not debarred from making the law over the policing. It means that it means the state government could also make the laws on the same matter, but the powers would be given to the center, or you can say the central law will have overriding power on the state law. All right, that will be the thing. The laws made by the parliament on the state subject to the national emergency became inoperative after the 6 months of the emergency has been suspended to operate. Notably, while a proclamation of the national emergency is in operation, the president can issue ordinances on the state subjects also if the parliament is not in session. And this comes under the heading of ordinance making powers of the president. All right. Thereafter, further, the parliament can confer powers and impose duties upon the center or its officers and authorities in respect of matters outside the union list. Okay. It means that basically it lies with the parliament that they could impose the duties upon the central government officers or the authorities for the matters which not falls under the union list, or you can say the matters which falls under the state list or concurrent list. Okay, to carry out laws made by under its extended jurisdiction as a result of the national emergency. Okay, thereafter the 42nd Amendment Act of 1976 provided that two consequences mentioned above, the executive and the legislative, extend not only to the state where the emergency is in operation, but also to any other state. Okay, which means that suppose, for example, if the emergency is in force in the region of Uttar Pradesh, so it does not mean that the central government could empower, or you can say could exercise the power of the government of Uttar Pradesh only. They could even reach the Madhya Pradesh, Okay, Tamil Nadu, and any other state as well. Okay, so remember this thing. Whenever the emergency is in the force, doesn't mean that the area in which is in the force that only be considered under the control of the government. But the central government could also exercise the powers to any other state for the same. Okay. Financial, while a proclamation of national emergency is in operation, what happens with the financial? Basically, the president can modify the constitutional distribution of revenues between the center and the states. Okay. Like whenever we talk about the revenue and the financial distribution between the center and the states, then this is done on the basis of the constitution of the country. Okay. This means constitution of the country. But whenever the financial emergency is in the force, basically the provisions of the constitution could be modified without making any formal amendment. All right. This means the president can either reduce or cancel both, reduce or cancel the transfer of finances from center to the state. Okay. Like in the normal times, the constitution provides that it's the responsibility of the center to gives the net proceedings. Net proceedings which calculate from minusing the total amount subtracting from the amount collected to taxation and the total expenditure occurred in collection. All right. So after subtracting the total amount collected from the total expenditure occurred, what we will get? We will get the net proceedings. All right. So in the normal times, the net proceedings are basically divided as per the recommendations of the Finance Commission, which is a constitutional body, okay, and appointed in every 5 years. All right, and prior to it, but depend upon the president. But during the cases of the financial emergency, the President of India can completely reduce or cancel the transfer of finances from the center to the state, which is functional in the normal times. Such modification continues till the end of the financial year in which the emergency ceases to be operated. It means that suppose if the emergency was in force from 2016 to 2017, for example, or if we're talking about the financial year, then from 1st April 2016 to 31st March 2017. Okay. If the emergency is in the force during this time, then what will happen? That when the emergency will revoke, okay, so till we reach 31st March 2017, the provisions which were made during this financial year, or you can say the year in which the financial emergency was in the force, so the provisions will continue till the end of the financial year, okay, in which the emergency ceases to be operated. Also, every such order of the president has to be laid before the houses of the parliament. Then only the thing could be done. All right. After the center state relations, the next heading what we had the effect on the life of the Lok Sabha and the state assembly. Okay. While a proclamation of national emergency is in operation, the life of Lok Sabha may be extended beyond its normal term, 5 years by a law of parliament for 1 year at a time for any length of time. What is happening? That basically whenever we talk about the general elections for Lok Sabha. So what we know that the candidates who got selected, or you can say who got elected by the people of India, okay, to represent them in the Lok Sabha, these people or the candidate could hold their position in the Lok Sabha for the maximum time period of 5 years. Thereafter, they have to face the elections again. All right. So normal time span of the Lok Sabha after getting elected or selected basically is for the 5 years. Okay. But if the national emergency is in force, okay, or is in operation, the life of Lok Sabha may be extended beyond its normal term of 5 years, okay, by a law of parliament for 1 year at a time, all right, and for any length of time. Got it? That's the thing. However, this extension cannot continue beyond a period of 6 months after the emergency has ceased to be operated. For example, from January to December, okay, for this time period, the extension was granted to the Lok Sabha. All right, but what happened? That till we reach July, or you can say in the starting of the January, what happened? That the national emergency was ceased. Okay, so basically, instead of continue the time span from January to December, the Lok Sabha could only continue it from January to July. Okay, because if the national emergency was revoked, then the extension could only be continued for 6 months, not for 1 year. All right. So, for example, the term of the fifth Lok Sabha, which was presented between the 1971 to 1977, was extended 2 times by 1 year at a time. Okay. Similarly, the Parliament may extend the normal tenure of a state legislative assembly 5 years by 1 year each time for any length of time. Okay. Parliament may extend the normal tenure of state legislature 5 years by 1 year each time for any length of time during the proclamation of the national emergency or when the national emergency is in the force, subject to the maximum period of 6 months after the emergency has ceased to be operated, similar like the condition of Lok Sabha. All right. Why we are not talking about the Rajya Sabha and state legislative council? Why we are not talking about it? Because for this there is no provision for direct elections. Okay, no provision for direct elections for them, right? That's the thing. Thereafter, third heading was the effect on the fundamental rights. Remember, the fundamental rights basically granted for the political freedom, right? Granted for the political freedom. So, what happens with the fundamental rights while the emergency provisions were in the force? First, Article 358 and 359, because the emergency provisions lies from 352 to Article 360. Okay. So basically, the Article 358 and the Article 359 describe the effect of a national emergency on the fundamental rights. So which article contains the effect of the national emergency and the description of it? Basically, the Article 358 and the Article 359. All right. Article 358 deals with the suspension of the fundamental rights, okay, guaranteed by the Article 19, which is the right to freedom. Article 359 deals with the suspension of other fundamental rights except those guaranteed by the Article 20 and the Article 21. So remember that when we talk about the Article 358, basically it suspends the fundamental right provided by the Article 19, which is the right to freedom. Okay. Thereafter, the fundamental rights, other fundamental rights, basically they will be suspended by the power of Article 359, except those which were provided by the Article 20 and the Article 21. What are these articles? So basically remember that Article 20 provides immunity against detention or arrest on unlogical grounds. All right. And the Article 21 provides immunity against, or you can say, provides a protection for life and personal liberty. Okay. So it means that basically, if we talk about the fundamental rights, so we will have a detailed discussion on it in the upcoming lectures. Till then, just remember that basically in the Constitution, from Article 14 to Article 32, 14 to Article 32, there is the provision for the fundamental rights. All right. So all the rights got suspended during the emergency provision except two articles, 20 and Article 21. These two articles could not be suspended during the national emergency. Okay. These two provisions are explained below. First is suspension of fundamental rights under Article 19, on which ground it to be happen. According to the Article 358, when a proclamation of national emergency is made, the six fundamental rights under the Article 19, right to freedom, are automatically suspended. No separate order for this suspension is required. Okay. It means that there is no need for the resolution. While a proclamation of emergency is in operation, the state is freed from the restrictions imposed by the Article 19. All right. In other words, the state can make any law or can take any executive action abridging or taking away the six fundamental rights guaranteed by the Article 19. Any such law or executive action cannot be challenged on the ground that they are inconsistent with the six fundamental rights guaranteed by the Article 19. When the national emergency ceases to operate, automatically the Article 19 revives and comes into the force. All right. Any law made during the emergency to the extent of inconsistency with Article 19 ceases to have effect. All right. So students, basically in this lecture, we have finished it here. In the next lecture, we will continue from here. Till then, just revise all the facts and figures, whatever we have discussed in this lecture. Keep yourself ready for the next lecture. With this note, let's end this lecture and thank you.